Hello, thank you again for tuning in. As you remember, my name is Matthew Pospisil, and I'm an attorney here at Parnham and Associates. Now, today we're going to be talking about affirmative defenses here in Texas. Affirmative defenses are something that the defense will have to prove, that the plea, and prove that during the course of a trial. Now, typically in a criminal trial, the defense has no burden of proof. That burden rests on the prosecution or the government to prove their case beyond a reasonable doubt throughout the course of a trial. But when it comes to an affirmative defense, that burden then moves to the defense to present evidence of that claim going forward. The most typical common examples of affirmative defenses are going to be issues of like mental insanity, mistake of fact or law, intoxication, duress, and entrapment. We're going to kind of cover each one of those topics today, except for insanity, which will be handled in a separate video later on. Going forward, let's talk about a mistake of fact. Now, the tricky thing with affirmative defenses is it typically requires the defendant to actually admit guilt of that offense, which makes things a little bit harder if you're trying to win a criminal case against you, because you have to actually admit that you did something wrong. This is where a mistake of fact can come in. A mistake of fact can be raised as an affirmative defense if that person reasonably made a mistake, and that mistake would negate that criminal intent going forward on a crime. A really good example of this would be, let's say you're on the subway and you have your iPhone out. You're playing on it, you put it on the chair next to you. You start talking to somebody next to you. Next thing you know, you pick back up an iPhone and you walk off the subway. You think that iPhone was yours, but in fact it was somebody else's. Right then you would have committed theft, a crime. You stole someone else's iPhone. That was not your possession and now it's yours. Going forward, you made an honest mistake. You can talk to the court and try to raise that beforehand, but the state may still try to make you go through a trial, even after you return the cell phone. So going forward, you would raise that defense during trial. It was an honest mistake. We made a mistake. You didn't have the criminal intent necessary to commit that theft or that stolen property. Should you have been punished? Well, that's going to be up for the jury to decide, unfortunately. All affirmative defenses that we talk about are going to be based upon what the jury will assume and find in that case. In the example I've given you, I think it's a pretty good case to make that it was an honest mistake. You had no intent to go forward in committing a theft or stealing someone's iPhone. Another type of mistake allowed is going to be the mistake of law. Now, the mistake of law is a rather tough one to actually prove as well. In order to be acquitted of your charges on a mistake of law claim, you're going to have to prove that you were relying on a piece of written statement of a government official or the advice of a government official who's in charge of that law, and then your reliance on that law was reasonable. To kind of put it into perspective, let's say tomorrow all over Facebook you're going to see this plastered on social media pages about the Office of the Attorney General of Texas is now declaring weed to be legalized in Texas. You're allowed to now smoke recreational marijuana for both recreational purposes and medical purposes. Now, it's still illegal today, but according to social media, you are now relying on the Office of the Attorney General who is telling you that it's legal. So you get busted smoking a doobie out on the street. Next thing you know, you're trying to say, well, this isn't fair, I relied on this. Going forward, you need to bring in that documentation and try and prove to the jury that you were relying on this statement, that you were of reasonable belief going forward to think that, yeah, it's now legalized according to what the Attorney General is telling you. Lo and behold, you find out, of course, that it wasn't the Office of the Attorney General making that statement. It was just some photograph out there. But your reliance on that would be reasonable. And of course, it would be up to the jury to decide whether or not you were reasonable in that belief. Now, I think with the growing trend in marijuana laws, it would be rational to conclude that you were being reasonable. I think it would be unreasonable on a corollary point to say, the Office of Attorney General posts out there that murder is now legal. I think it would be hard pressed to find anybody who would be reasonably thinking that murder is now legal in the state of Texas. Another common affirmative defense you will see is going to be duress. In order to survive a claim of duress or present evidence of duress, you have to show that you are committing that illegal act because of fear of imminent death or serious bodily injury is going to be coming your way or to a loved one. A classic case of this you see in movies all the time are hostage-type situations where kidnappers take a person's family, hold them hostage saying, we're going to kill them if you don't do X, Y, and Z. And so you go and commit that crime. All this kind of evidence would need to be brought out into the jury, and they would have to make that finding whether or not you were of reasonable belief that you were in serious threat of death or serious bodily injury. And then our last big affirmative defense topic is going to be entrapment. In order to be on a claim of entrapment as a defense, you're going to have to be able to show that government agents or people working for the government or state of Texas were using means of coercion to get you to commit a crime, farther than just setting up a mere opportunity for that crime. A very common scheme that people see all the time and try and claim as entrapment are prostitution cases, where you walk into this room and you have an undercover officer pose as a prostitute offering up sexual services for the cash, and they try and claim an issue of prostitution being an entrapment. The real issue with those kind of cases comes down to whether or not they are actually trying to induce you into committing that crime, or just performing a mere opportunity or establishing a mere opportunity to commit that crime. If your loved one has been accused of a crime and you think you have an affirmative defense for it, it's imperative that you contact a lawyer immediately. The quicker to get started on cases of these types, the better. Here at Parnham & Associates, we have great experience handling these kind of matters, ranging from any kind of affirmative defense. Give us a call today. Thank you.